refugee laws. But in practice, it has shown more generosity to refugees, including millions of them from my own country, Bangladesh, in 1971, than many other states that do have laws. I was chief of mission here with UNHCR in the late 90s, and I saw how it worked in practice. So as the Indian courts consider the case of the Rohingyas from Myanmar, I hope that same spirit of compassion and humanitarianism will prevail. As Secretary General of Amnesty International, I found myself confronting the US-led war of terror, in which the world's most powerful government locked people up indefinitely without charge or trial, engaged in waterboarding and other torture tactics, and carried out extraordinary renditions with impunity. Now, some of the detainees in Guantanamo fought the US government in the Supreme Court and won their case. But even strong institutions have their limits when there is no political will to respect the rule of law. Now, let me tell you the story of Rosie. It's a true story, but I'm not going to tell you in which country Rosie lived, because it doesn't really matter. There are too many Rosies in the world, and this story of Rosie could have happened in South Asia as much as in Southern Africa. Now, I never met Rosie, but I heard about her when I visited a counseling center for women victims of violence in a country that had just introduced a new law to combat domestic violence. And this law is one of the best drafted laws in this area. And I had actually gone to that country in order to study that law. And the local government had set up a counseling center for women who wished to use the law, submit their complaints to the police, and get a protection order. And the counselor in that counseling center explained to me how easy it was to do that, no hassle, no cost, very simple. And then she told me about Rosie, a poor woman with 5 young children, no job, no education, a victim of domestic violence. On payday, her husband would come home, get drunk, come home, and then beat her up. He did that several times. She was hospitalized with injuries. And then one day, he beat her so badly that she actually died. So I asked the counselor, why hadn't Rosie sought a protection order from the magistrate? What was wrong with the law? And the counselor replied, there is nothing wrong with the law. Rosie didn't have the money for the bus fare to get to the magistrate's court. So if my experience with UNHCR and Amnesty International showed me that law can too often bend to political will, Rosie's case taught me that even good, well-meaning laws and institutions can fail to provide justice if they're disconnected from the lived experience of poor people. If the rule of law is to be a pathway to sustainable development, then in the words of Professor Harold Berman, justice based on law must give way to law based on justice. Now, Amartya Sen, in his book, The Idea of Justice, rejects this transcendental, what he calls the transcendental approach to justice, which concentrates primarily on getting the institutions right. He champions a comparative approach to justice, addressing injustice where we see around us, rather than trying to create a perfect state of justice, on realizing justice in societies than focusing on institutions and rules. And in the words of Professor Sen, the question to ask is whether the demands of justice must be only about getting the institutions and rules right, or should we not also have to examine what does emerge in the society, the kinds of lives that people actually lead. He says, justice cannot be indifferent to the lives of people. End of quote. Now, justice is people-centered. It is about creating fair outcomes and an inclusive society. The rule of law, on the other hand, is state-centered. It is about institutions and governance, the application of norms, procedures, and regulations. The rule of law is a highly complex concept, and even lawyers struggle with defining it properly. And it is inherently political concept because it involves values, choices about justice, governance, accountability, and rights. And so it's not surprising that there is no one universally agreed definition of the rule of law. And that is, of course, in itself a problem as we look at the SDGs. Now, at a minimum, the lowest common denominator definition of the rule of law would be of a system of rules and institutions to constrain the arbitrary exercise of power. And in this minimalist definition of the rule of law, laws must be clear, prospective, and capable of being followed, impartially applied, and equally enforced by institutions. The key features are predictability, clarity, legality, and due process. Very often, however, this turns out to be not rule of law, but rule by law. Now, the UN Secretary General offers a broader definition of the rule of law, which is closer to the concept of the rule of law in most democratic societies, including India. And he defines it as a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. In this definition, the rule of law guarantees the protection of the full range of human rights and provides to citizens and non-citizens legitimate avenues of recourse in case of abuse of power. And in that sense, the rule of law actually operationalizes human rights. That relationship between the rule of law and human rights is important, otherwise human rights are nothing but paper promises. Now, human rights are, of course, constraints on state power, for instance, by prohibiting torture or restricting free speech, or stopping the restriction on free speech. But they are also enablers for state action. For instance, putting a duty on the state to provide education or healthcare or housing. They are effectively claims that the weak advance to hold the powerful to account, and they empower and confer dignity on poor people, on the marginalized. Now, the UN's understanding of the rule of law is what we in IDLO follow. It contains, as you see, both procedural as well as substantive elements of justice. Now, India has an independent and internationally well-respected judiciary with a reputation for upholding the rights of the marginalized and vulnerable and providing remedies for violations. And many Indian decisions on economic and social rights have been hailed globally. Now, India's best, and I say this because what is most surprising is, of course, under the Indian Constitution, economic and social rights are not framed as rights, but as principles of policy. And yet the court has read those principles in a way linking them to the right to life and has given them life, has given them real life and reality. And this takes me back to what Amartya Sen said about looking around and see what is needed to be done in terms of justice and to do it. And I think the Indian Supreme Court did that. Now, India's best-known public interest litigation case is the right to food case. Over 2 decades, the court monitored every government scheme related to food, both at state and central levels, even appointing its own officers to explain what was actually happening in the courtroom. And then the National Food Security Act, which came in 2013, was partially as a result of that judicial scrutiny. It shows how laws and institutions can have a tremendous force for protecting the rights of those living in poverty. Now, more recently, we have seen the decision of the Indian Supreme Court in March 2013 to reject the patent application by Novartis, the international pharmaceutical firm, for its cancer drug, Gleevec, on the grounds that the company was evergreening an earlier drug. And so it rejected Novartis' application. And the court used Indian legislation as well as the flexibility in the TRIPS agreement. This is the trade-related intellectual property rights agreement, to take into account the social objectives of healthcare of Indian people. And as a result of that court decision, taking away the application that Novartis was trying to enforce on intellectual property, millions of poor people in India are able to access a drug that they badly needed but could not otherwise have afforded. So, are the interests of a large multinational pharmaceutical company to continue to make profit from essential medicines to be put on par with the needs of those who are too poor to buy essential drugs. And the Supreme Court, of course, rightly decided not. Now, in the court of law, a poor man or woman has no more rights than a rich man. Now, as Anatole France, the French journalist, poet, and novelist, famously said in 1894, "The rich, as well as the poor, are forbidden to sleep under the bridges of Paris." But the law sometimes, when it dispenses equality, needs to take into account, as the Supreme Court did in the Novartis case, the asymmetry of power. And poverty is about powerlessness. We say, of course, the law is blind, but legal blindness to power dynamics can be dangerous. Look at the situation of women, for example. And here, I'm going to give you an example from the international level. The Universal Declaration of Human Rights, which the United Nations adopted in 1948, which is the kind of apex document on human rights, is gender blind, makes no reference to the different ways in which men and women experience human rights. And as a result, for many years, the international community ignored the issue of gender discrimination or sexual and gender-based violence. It took the women's groups, the women's movement, 30 years of mobilization before the UN adopted the Convention on the Elimination of Discrimination Against Women in 1979, and another 16 years before the Beijing Platform for Action on Gender Equality came into being. Now, another little side fact, trivia, if I may put it that way, is that whereas the UN Convention on the Elimination of Racial Discrimination took 6 years or so to come into being, the one on elimination of discrimination against women took about 15 years. So make what you will of that. Now, but I think the women's movement and the gender conventions that came into being show that, like laws and courts and state institutions, social movements also have a great role to play in making the rule of law work for everyone. Civil society is an important actor in making the rule of law work for sustainable development. Now, sustainable development requires the balancing of diverse interests. Hard choices have to be made on how to distribute the benefits and burdens of development. Take the Narmada Dam case. The Supreme Court was confronted on the one hand with India's growing needs for reliable water, and on the other by the rights of people who were being ousted from their land. But unlike the Novartis case, where the Supreme Court took a clear stand, backed by national and international law, in the Narmada ruling, I would say the Supreme Court basically hid behind a technicality and ducked a proper analysis of the issues. Now, the former ambassador and now Minister Hardeep Singh Puri, the chair of RIS, often says that just as the success of MDGs rested on China's anti-poverty efforts, the success of the SDGs will be determined by India's ability to lift its poor people out of poverty. 1/3 of the world's poor, about 400 million people, live in India. And India is pursuing a strategy of industrialization and economic growth to eradicate poverty. Without growth, there can be no development. But of course, not all growth leads to development. So what kind of trade-offs should India make, or can India make? How will it decide what is equitable or not? Whose voices will be heard? How open and participatory will the decisions be? When disputes arise, how well will they be adjudicated among parties with different levels of power and influence? These are precisely the kinds of questions that a well-developed system of the rule of law can help to address. And so the imperatives of poverty eradication should not be considered to be in opposition to or isolated from the principles of sustainable development and the rule of law. On the contrary, the SDGs require an integrated approach to development. So it is about sustainable development, economic development, and environmental protection, but it is also about respecting the rule of law and promoting equity and fairness. Constitutions, laws, and courts matter, but so do, and I would say possibly even more so, the values of justice, inclusion, and equal protection at all levels of state and society. Last night, I was having a conversation with one of your leading lawyers, and he talked about the values of Indian culture, history, going back thousands of years, of communal support, of communities supporting each other. And it is those values that actually go to build the rule of law. The Constitution is a piece of paper with a few words on it. And what's much more important in how that Constitution will survive decades, possibly centuries, is about those embedded values of society.